Hi, good afternoon. My name is Michael Robinson. I'm a director and solicitor at Emmersons Solicitors Limited. I want to talk to you today about motoring offences. I suggest that you do not undertake detailed research on the internet. There's a lot of rubbish published on the internet about how you can challenge speed cameras, how you can challenge drink driving offences, loopholes that supposedly exist. There are no loopholes. What there is the law and the knowledge of the law and the application of the law to a particular case. Often in court it's not what you say but how you say it that makes the difference. In order that you can get the best advantage in court, what you ought to do is seek advice from a solicitor such as myself who specialises in motoring offences. It's not the only area of law I cover, but I do spend a lot of my time in court dealing with motoring offences, and I've built up a great deal of experience over the last 20 odd years, and indeed I hope a good reputation as somebody who represents their client appropriately, forcibly, properly in the courtroom, and advises them properly about what is likely to take place so that they fully understand the options that they have and that the eventual outcome is one that they have anticipated because it has been suggested to them that that is what is likely to happen. Too many people make too many grand promises for people on the internet, and I would advise everybody to seek advice from a solicitor. One of the things that causes people greatest concern, of course, is when they accumulate penalty points and face disqualification from driving. What you need to know is that you can mount an application to the court in order to keep your licence even though you've accumulated 12 or more penalty points, and that is called an exceptional financial hardship argument. What that means is that you have to show that exceptional financial hardship would be caused to yourself or indeed to innocent third parties, and the court therefore ought not to disqualify in those circumstances. It's a very difficult argument to make because of course the court is in the position of having to disqualify somebody who has accumulated 12 penalty points or more, but that doesn't mean it shouldn't be made, and it doesn't mean it can't be made in a way that gives you the best chance of achieving what you are looking for. If you want legal advice and if you want representation in court in relation to motoring offences, then do get in touch with us because we're only too willing to help.